Yes. I'm late. I know. Sorry. How is everybody doing? Welcome to Dolly Talk. This is Ilya, Dolly, T-Bone, Satchel, Paige. All the good ones. How is everybody? Justin, yes. Mavka, how are you? Bye, Franz. Good to see ya. Maddie's here, and Mads. Got Johnny here. Sasha, nice to see you. Oh, and Hella. All right, so we're going to do some Judge Simpson right off the bat. Oh, hello, Rachel. Oh, shut up, Hella. It's been a day. What can I say? Look, I even set up my stream to automatically promote you. Like that. Because I'm a good friend. All right, so I'm going to be trying to oh, shut up. I'm going to be trying this in VLC, so we'll see how it goes. If not, then we can just do some videos in YouTube, but... Oh, God damn it, Mavka. Hey, Lefty, how are you?
County Washington State of Michigan is now accepted. All those have been
Ooh, Ashley.
Cedric Simpson presiding.
You may be seated.
She looks like getting ready for her OnlyFans.
And on the prosecutor's side, who is going to, or is Ms. Landy going to do it remotely?
I'm happy to do it remotely, Your Honor. Good morning.
How are you so special?
I am.
She can do it remotely, like a lot of my women. Wait.
I'm within an ice rink, so I appreciate the accommodation for me. I really do. Thank you.
No, and we had no problem doing that. Although the rest of your office is here. But go ahead,
They
please, Ms.
are
Landy.
an
Oh, look at Brian in the middle there. He's having fun. He's in a good mood. You know, it's all laughs where he's at.
a bunch, are they not?
Yes, they are.
Good morning, Your Honor.
ahead.
Ashley Landy. For the people, at this time, the people would waive any conflict between this honorable court and the Office of the Public Defender. People do not believe that any conflict exists and make the waiver for the avoidance of all doubt.
Thank you.
Okay.
Morning, Judge.
Good morning.
We likewise do not believe that a conflict exists, and we would also waive any conflicts in this court. Thank you, Your Honor.
Well done.
That's
And the
nice
court,
of
for
you.
its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent the conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case of the People versus Beverly.
Consent
Boss.
is always good.
I'm a
Ashley
stud.
Landy for the people.
Brian Bowling on behalf of Ms. Boss.
Ross, could you state your name, please?
Beverly Boss.
Thank you. What are we doing?
Judge, we're here for basic evidence review related to a competency order that was previously entered. There's been an update to that indicating that Ms. Boss has been restored to competency.
Yes.
We would stipulate to that report, have no objection to it, and ask that this matter be reset for a probable cause conference.
All right. Anything else from the people?
No, Your Honor. Thank you.
Where's
All right.
Forbes' daddy at?
Court will indicate that based upon the report, the defendant now is competent and has been restored to competency and can understand the nature and objects of proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent.
What was what?
And Mr. Bowling, I'll need orders. please.
Sure, fair enough. Yeah, I'll provide those, Judge.
All right. And would you like to set for?
For probable cause conference, I guess, because we never really got into any plea discussions with this matter, Your Honor. So
How much you want to bet this asshole just blurred out the room, went to Home Depot, got some tubes, and just like glued them or taped them to his chest, blurred out the room, just gets like a old pillow to prop himself up. And this guy's slick.
So I think I'd like an opportunity to do that.
Today is a 6. Probable cause conference will be set for February 20th. 2025, 9 a.m.
Thank you, Your Honor.
Bond in this matter will
Quit
continue.
fingering the
Thank you,
camera,
Ms.
sir.
Voss.
Will I be able to get out today? On my bond?
She
Say
has
no,
posted
Judge.
bond, so it's,
Posted bond.
she has.
Yes,
So,
I
yeah,
have
you-
that.
Shouldn't be any problem.
Ms.
Shouldn't be any
Voss.
problem, at least on these cases.
Thank you, Judge.
You. Court does call the case of the people versus Ahmet Enenreich.
Aaron Reicher. An assistant public defender, Jay Bellinger, on behalf of Aaron Reich, who appears via Zoom from the Forensic Center.
The Forensic
Sir, can you
Center.
state your name, please?
Yes, Amit Ehrenreich.
Thank you.
Amit.
Thank you, Your Honor. It's my
Van
understanding
Dyke?
we're set for competency review today. We have received that report. We would be skipping to his competency at this time. It's my understanding that he's undergoing treatment right now. He's been restored, though. I would also ask, I did provide a filing to this court this morning with regard to the mental health treatment court that was signed by Mr. Childers. I would ask for this to be reset for a PCC at a time appropriate for review of that mental health treatment court application, which I will today for review. And I will also be opening an AIM file with my office to help him see about housing, disability, et cetera. So would ask for some time for that with regard to the adjournment. I would also request one more thing, Your Honor. I'm sorry. I don't know if the court has already signed an order for him to work with CMH, but I would ask that the court
Someone's needy
do
today.
that if it hasn't.
Send me over a stipulated order, then.
Certainly.
No problem.
Certainly.
Anything from the people?
Your Honor, people have reviewed the competency report as well as the defendant has regained competency to order to that effect. I have no objection to the request by Mr. Bellinger regarding mental health treatment court in German.
All right. Court, having reviewed the report, the defendant has been restored to competency and can understand the nature and the object of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I will set a probable cause conference. I've signed the order regarding mental health court. Why don't we at least give a shot? I'll just do the 27th. Is that going to be enough time?
I'm sorry, 27?
Yes.
I believe that would be just fine, Your Honor, at least to get things going.
February 27th, 2025, 9 a.m. Bond in this case will continue.
Thank you.
Thank you. Court does call the case of the people versus Jenny Glue.
Ashley Lonnie for the people.
Public Defender Fellow Nicholas Bukovich on behalf of Ms. Liu.
Ms. Lou, can you state your name?
Say no, Lou.
Sir, Jenny Lynn Lou.
All right.
At this time, Your Honor, we'll be requesting adjournment for the mitigation process to be finished. We've been having some issues getting into the jail due to the new visitors process. I was able to speak to Ms. Liu this morning, and she did see the visitor applications for 2 of the APDs, so hopefully we'll be able to visit her soon. I also know our AIM specialist has a meeting with her tomorrow to finish the mitigation.
Oh my
report.
God.
I
Come
believe
on,
she
Elmer
may be
Fudd.
reviewed. I would be asking for an adjournment a couple of weeks out.
We had her case yesterday. Ms.
Oh.
Lou, what date did we set that for?
Did I offend him?
Ms. Lund, did you recall?
I think it was 3-5.
I believe March 5th.
March 5th.
I did confirm it was March 5th in JIS, Your Honor.
I thought I saw a rabbit.
All right. Then what I'll do on this one is set it for March. Okay, we set, right. So let's do this. I'll set these probable cause conferences for March 6th. Because I had
Okay.
indicated we were going to try to keep them together. March 6th, 2025, 9 a.m.
Be
All right.
very, very quiet.
All right. And we'll continue. Court does call. Ms. Lou.
Thank you, Your Honor.
Thanks, sir.
Court does call the case, People versus Gregory Callahan.
Hey, Angie.
Good morning, Your Honor. Advisor, and good morning, Your Honor. We're pleased this honorable court, Lydia Young, 44626, appearing on behalf of Mr. Gregory Callahan, who is present.
No, I don't think the dude's in the hospital. I think he just like did a transparent or did the blurry background and just stuck some tubes on his chest.
Sir, would you state your name, Judge, please?
Gregory Callahan. All right, thank you. All right, what are we doing in this case?
Judge, we are ready to
These
set a
cases.
preliminary examination. Hearing
The-
date, please.
There are co-defendants.
There are.
So I would like them set together if possible.
All right, are all of them requesting?
I'm not sure. I see counsel
Not.
for one here,
Who's this?
counsel for third co-defendant.
Feaster.
Mhm.
Mr. Feaster is,
My client is Mr. Finley. sir.
Mr. Schfinkter?
yes, and I received a request for an adjournment, so yours is not,
But we're not done investigating, Your Honor.
pardon?
We have not completed our investigation. Mr. Green is still looking into what he met with the client. But we
Sorry.
have no, and he's looking into the, the issue of the credit.
And your client, although they're not here, are they, Sparnwell, they're ready for exam?
Your Honor,
Or-
I was under the impression that something else was forthcoming from the prosecutor this morning.
So discovery is not complete?
I received immediate discovery that was, and some additional documentation. So I'm assuming I've got all the discovery now. And this was received since we were in court last, a couple of years ago. Yeah.
I've been getting them in a continuing stream of discovery, Judge. Tons of electronic as well as paper.
Okay. Okay, so I get that. I guess what I'm asking is there more that's coming or?
Phrasing,
There is
Judge,
one, Your
phrasing.
Honor, there is a search warrant outstanding for records from Samaritas. We expect those documents.
Bye, Lefty.
next week. There was one additional forensic interview conducted last week of the 4-year-old minor child, and that will be forthcoming. But other than that, the bulk of the discovery has been provided. There are items that are at the crime lab for DNA analysis. There was a swab taken from each defendant pursuant to a search warrant. So there is some information still forthcoming, but
Why don't we do this?
Forbes, what's going on, buddy?
Let's take him back.
Oh, I think he
and
wants
I'll
his sponge
counsel on
bath.
These approach, please.
Yes, ma'am. Sir.
Lucky guy.
Not really.
Hey, factual lie. Come on. Ooh, let's watch this guy pick his nose. Now, see, you don't get that on just any other stream. Okay, watch this. Oh, yeah. Raise his hand. What's going on here? See what he does. See how he handles this. Okay. Oh, it gets that hard paper. There we go. Oh. Come on, buddy. Don't examine it. Who's this dude with the tits? That's Brian Brown. I hope he has a brassiere. Now what's he doing? Boy, there's so much going on right now. Good Lord, how much mucus does he have up there? His nose is running more than Nick Ricada's. Okay, let's skip forward.
This guy's in.
Good times.
Court does call the case of the People's State of Michigan versus Forbes Dabney.
Babu.
Thank you. Thank you.
They already got their Wetties today.
Prosecutor.
I'm sorry, I didn't catch the name.
Dabney.
Dabney.
What's going on?
Pay attention to the screen. They're talking.
I think it was an add-on.
Andrew Childers, attorney on behalf of people.
Torsia Feaster, Assistant Public Defender on behalf of Mr. Dabney. Mr. Dabney, can you please state your name?
Mr. Daphne?
What happened? State your name. In special appearance, this is for Dabney Jr.
Thank you, Judge. I was told that this was added on to the docket and my office had not yet went out to speak to Mr. Dabney to try to find out where we stand and if the resolution is possible. So I will be requesting a 2-week adjournment so that we can speak to Mr. Dabney.
All right. Without objection, probable cause conference will be adjourned to February 20th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge.
Thank you.
That was productive. Bye. Hope you have more mucus blowing sessions.
Court calls the case of the People versus Marissa Bridgman.
Jeez, now that's a folder. What the hell is he wearing? This guy just get back from Jamaica? What's under his robe?
Your Honor, Sam Bernstein with and on behalf of Ms. Bridgman.
Your Honor, I believe Ms. Fudge is coming, but Marie can't up for the people until she gets here.
All right. You're requesting an adjournment?
Yes, Your Honor.
All right.
And Your Honor, I'm assuming that Mr. Bernstein has spoken to Ms. Reiser.
Here she comes.
Good morning, Your Honor. Amy Reiser on behalf of.
All right. Requesting an adjournment on this.
Yes, Your Honor.
Probable cause conference will be adjourned to February 27th,
Thank you, Your Honor.
2025, 9 a.m. Bond will continue.
No, I think
Thank
he
you.
just got back from Hito.
Court does call the cases of the People versus Philip Brown.
Junior, it's okay.
Joseph and all the people?
Stephanie Cannon on behalf of Mr. Brown as it relates to case number 25F20094.
Good morning, Your Honor. Please just on Court David Burgess on behalf of Philip Brown as it relates to the remaining matters.
Mr. Brown, could you please state your name for the record?
Philip Brown.
All right.
And Your Honor, I will let you know that I did file an adjournment because I had not had the opportunity to speak to Mr. Burgess yet. I'm not going to be requesting adjournment. I'm going to ask for this to be set for a PE.
And I spoke to Mr. Brown regarding this matter. Judge, discovery is complete. As it relates to that, we're asking for an exam date in this matter. I believe the prosecutor is ready to proceed as well.
And just for the record, Your Honor, I don't believe I think at the PE, my case will be just moving along with this. So we won't need, you can do them both on the same day. If the court would like, I'm sorry.
Thank you for the consideration.
Thank you, Your Honor.
Yeah, I appreciate it. All right. All discovery is complete then.
Yes, Your Honor.
And would the people have their witnesses available on the 18th?
I believe so, Your Honor.
Preliminary examination will be set February 18th in person before Judge Washington at 9 a.m.
One copy.
Whoa! Did his
Thank you so
chest
much, Your
just
Honor.
Bond
move?
will continue. Thank you.
Judge, my client did want me to address bond. I know.
Oh.
Sorry, Your Honor. I understand the serious nature of the charge that I'm representing my client on. How
I think at the PE,
the facts of
will be just moving along both. If it's the same.
Yeah, it's on.
I believe so, Your Honor.
Preliminary examination will be set February
Looked like his
18th
chest kind of like gave a wink.
in person before Judge Washington. At
Oh,
9 a.m.
maybe those are his arms inside.
Thank
his
you so much,
state.
Your Honor.
Bond will continue. Thank you.
Judge, my client did want me to address bond.
Or his third
Sorry,
nipple.
Your Honor.
I don't know.
I understand the serious nature of the charge that I'm
Hey,
representing my
Lexi.
client on. However, the facts appear to be, Your Honor, that my client was at his home, his residence. The alleged victims in this case came to his residence. The weapon in question was actually taken from the complainants, and my client used it in self-defense. That's going to be our position, and that is backed up by video from my client, both the ring video locally as well as video that his girlfriend has. So the facts are a little bit different than what the people claim them to be. So based on that, Your Honor, and he has not been in trouble for a number of years. His priors are very old. He does have a felony record, but they were very old, Judge, and he's not on probation or parole. The bond, I think, is currently set at $1 million. Judge just asked the court to consider a lower, more reasonable bond under the circumstances.
Response from
And Your Honor, I would make
Oh, go
a
ahead.
request as well, that his bond be lowered. I would actually ask for it to be a bit nominal in this particular case. And I would mimic everything that he said regarding his previous record was quite some time ago. And in this case, I know mine stems from him being in possession of a weapon, but he was not using a weapon. And after everything that had happened, he was just a little bit scared for his own personal safety. He is going to appear in court. He is not a threat to society. And do you mind being tethered to your house? He wouldn't even mind being tethered to the home, Your Honor.
response.
Yes, Your Honor, there are 3 separate counts of assault with intent to murder in this case, 3 separate victims, assault with a firearm. There's count of CCW, possession by privileged person, and this. And the case in the defender's office arises from this event being taken into custody with regard to the England charges. Given the violent offenses that are involved in this case, frankly, this level of assault behavior, and the fact that a firearm was involved, bond remains.
Court considering all of that and understanding also that it's self-defense. I understand what you're saying, Mr. Burgess, but that's something that can't be addressed at preliminary exam in any event.
Not with that
I
attitude.
understand there's going to be some difference with reference to the facts of this case, but in looking at everything, having reviewed the bond statement of the people, court would leave the bond set as it is in each case. Motion for bond reduction is denied. Bond will continue. Thank you. Court does call the case of the people versus Dimitri Butler.
And then the people.
Good morning again, Your Honor. May I please report David Burgess on behalf of Dimitri Butler, who's standing to my right. Sorry. Sorry about that, Judge. Your Honor, we are requesting an adjournment in this matter. If I could get 2 weeks, Judge. I just got appointed and I don't have discovery.
It's always
That
something.
objection, probable cause, February 20th, 2025, 9 a.m. Bond continue.
Thank you very much, Your Honor.
Thank you. And Sanilac County. Got it. Okay. Court calls the case people versus Demetrius Caldwell.
Ashley for the people.
Good morning,
Hey.
man. Please, this Honorable Court, Kareem Johnson, appearing on behalf of Mr. Caldwell, P number 71988.
Your name, sir? Demetrius Caldwell. What are we doing?
Your Honor, we would like to set this matter for exam. The court was informed by both the government and the public defender's office the last 2 times we were here that there was another case in which I do not represent Mr. Caldwell, and there were some competency issues in that case. And so the court was unwilling to set an exam until that was fettered out.
Well, has it been?
Your Honor, it has not, to my understanding. I think it's still pending.
You think?
Ms. Lundy, you check that to say it's still pending, or, because Mr. Feaster's looking, I go,
I checked last night, but I'll check again. I believe it was adjourned. The 15th District Court case was adjourned until late November. I'm sorry, late February, excuse me. But I'm checking now to make sure that nothing has changed. Okay. According to GIS, this was set for a competency hearing on 1/22. And then it was adjourned for defense to review the forensic center report. He was found incompetent and not restorable on 1/23. So he is found incompetent and not restorable on a different case. So I don't think that I understand what defense counsel is saying. I wouldn't characterize that as resolved. I think that that's a different issue now.
okay. So who has that report? Is it a PD case?
It is, Judge, it's not in the electronic file. I don't have a copy of my electronic file. I just have a note indicating that it was, that the report was filled at 122. I don't have a physical report in file.
Sure, I can do that.
Who said that? You got a copy? Okay, so that's gonna make it a bit difficult to set a preliminary examination. So I think what I'd like to do is I'm gonna adjourn it out, get you a copy of that report, counsel, so you can take a look at it and then figure out where you're gonna head with that. Because presumably if we had sent this, we would get the same.
Absolutely. May I address my client's bond when the court is done?
Sure.
Your Honor, this matter has been adjourned several times, waiting for this forensic report to be completed. It is my position that at the very least, Mr. Caldwell served, or would get a time credit for the minimum guidelines if he was convicted. And at this point, I anticipate filing a motion to have the case dismissed or working on that with the prosecution. So we'd ask the court to consider a personal bond for Mr. Caldwell at this time.
Okay.
Hey,
And
I'm not gonna need a response. I'm gonna deny the request and I'll explain why. The finding that he's not competent and not restorable typically means that somebody's gonna file a petition. The finding, which means everything is gonna go wherever it's going to go. And I don't know that his release pending that petition would be a wise thing to do. So, because I'm not, because I haven't seen the report either, counsel, so I don't know.
what I would anticipate doing is working with the prosecution for a stipulated order of not guilty by reason of insanity. And then we'll go to the probate court. And that's something that the prosecution, that will be on the prosecution to do. I don't know if they would agree to that, but that's what I would want to work on. I would want to keep him in jail, Jan.
Yeah, no, I'd like you to review the report. Let's see what that is. So at this time, I'm going to deny the request. I'll adjourn this out. I think they're working on trying to get that to you now. So I'll adjourn this out a couple of weeks to the 20th, 2025, 9 a.m. And then we'll take a look at it, figure out. Is it anticipated, that's a state case, Ms. Lundy?
Yes, Your Honor.
The one in 15.
In the top right?
Are the people anticipating a petition on that matter?
I don't know yet, Your Honor. I will work on that. However,
Post haste,
because he has been found
Ashley.
incompetent in that file, we may file a request for his competency to be evaluated in this file as well.
You don't seem very competent at the moment.
Probably a good idea. So
Yeah, I think the law requires a hearing within 5 days of receiving the report, Your Honor.
yeah, but that's not, if it were
Okay,
this
fine.
case, yes, all right, but I don't know. I think maybe what we ought to do is if somebody files an order for a forensic evaluation, I don't know that it's going to change. I'd sign it And then we could get to the competency hearing rather fast. I would doubt that the information would change in the report, and then I would have one in this file. And then we can figure out exactly what we have. So I think maybe that's what the party should work on, getting an order to me so I can sign it, let the forensic center know that they've already done the report, get the report in this file, and then move this file from that.
Yes, Your Honor.
All right. So we'll set it for the 20th, 9 a.m. Thank you. Bond will continue at this point.
This is what?
Fine. Hey, yeah.
Do you?
Well, hold on a second. What is more?
I don't.
Yeah, definitely.
They're gonna say it. So, okay. When they have everybody managing one vote, call three at the same time with one vote, and it's up.
And they come out at the same time?
Woodstock was saying yes.
The two here and then would be, yeah, we could, give me a second on doing that. But yeah,
Absolutely, because we gotta work.
yeah, okay. Court does call the case of the People versus Jamie Foxx.
Ashley Londy for the people.
You're Alice Friedman with Jamie Foxx.
Your name?
Jamie Foxx.
All right, you're requesting an adjournment on this.
Yes, Your Honor.
Any objection?
Your Honor.
20th date looks good.
Pardon?
The 20th date would be good.
Probable cause conference, February 20th, 2025, 9 a.m.
Do we have is the 2 slot open?
Pardon?
Is the 2 o'clock slot open?
Why, will you be on a plane?
No.
No, just, you don't have to answer that. At this time.
Yeah, he should have been.
So yeah, you should have been in the later block anyway, but that will likely go into a later block.
Okay, cool.
All right, if it ends up in the morning block, get to Diana. We'll figure it out.
Thank you, Your Honor.
All right, thanks.
Thank you.
Bond continued. Thank you. Court calls the case of the People versus Samantha Classic.
Ready, Your Honor.
Ashley Londy for the people.
Good morning, Your Honor. Joseph Paul Pinkford on behalf of Ms. Classic, who now stands to my right. Ms. Classic, if you could state your name for the record, please.
Samantha Nicole Classic.
Thank you, Your Honor. We're here for PCC today. We were last here 1 week ago. I appreciate the short adjournment and the purpose behind that. We are still awaiting the discovery, the call for service and dispatch. I'm sure we're going to get that squared away soon enough. We would ask for an adjournment to allow discovery to get completed.
Okay.
And
I'll adjourn it to the 20th, 2025, 9 a.m. Go ahead.
And Your Honor, if we may also address bond at,
Briefly.
very briefly, Your Honor, Ms. Classic is in here for a dirty marijuana test. She was forthcoming the last time we were here. She's attended AA or NA every time it's been offered to her in the jail. The point has more than well enough sunk in. She lives at home with her parents, and there will be no driving. We would ask that the court consider, and Your Honor, although it hadn't arrived as of yesterday, we have approval and a medical marijuana card we believe is in the mail. We understand that doesn't shore up the gap in time, but we would ask Your Honor to consider after 1 week a reduction in her bond that would allow her to be supervised in the public. She will comply with whatever testing would make the court feel comfortable.
Response from the people.
I went to high school. She was a
Your
real
Honor, I would
bitch.
leave it in the discretion of the court. I think the court already has all the information from the people, reference our concerns about the defendant having tested positive for several substances, going to inpatient treatment and coming out and continuing to test positive for marijuana. I will leave it at that.
And given the nature of the charge, that is the other thing that.
I understand that's playing into Your Honor's decision.
Is she working?
Well, no, she's in jail, Your
Not
Honor.
this, Your Honor, with treatment, and I believe so she got out of inpatient almost immediately before the last hearing, about a week, I think, prior to the last hearing. And the day that she went in was the day that she was going to go orient with outpatient. So treatment is her primary focus right now. If Your Honor wanted employment, I'm sure Ms. Clark.
No, I just wanted to know what she does during the day.
During the day, she'll be focused on her continuing treatment, Your Honor. I think that's where she believes, Your Honor believes, I and her parents believe her time is best spent.
Set this on the 20th. I'll reinstate the defendant's previous bond
Thank you, Judge.
with its conditions.
Absolutely.
Thank you.
Thank you, Your Honor.
Court calls case People versus Teresa Johnson. 3 cases. Yes.
Morning, on House of Prosecuting Attorney on behalf of people.
Assistant Public Defender Jay Bellinger on behalf of Ms. Johnson, who appears to be at Your Honor.
Ms. Johnson, can you state your name, please?
Yes, sir. Teresa Johnson.
All right. I have before me 3 plea forms. Is that what we're doing today?
That is correct, Your Honor. I previously sent the police reports for purposes of a no contest plea.
Yes. And they're all, as I understand, they're all no contest pleas.
Yes, yes, Your Honor.
All right. And the plea form starting in case ending in 5152 indicates that she would be pleading no contest to the charge of the stated count of assault and battery and an added count of attempted resisting and obstructing, the assault and battery being a 93-day offense and the attempted resisting and obstructing a 1-year offense. Also on case ending in 5189, she will be pleading no contest to the same charges of assault and battery, a 93-day offense, and attempted resisting and obstructing a 1-year offense with dismissal of count 1. There was also a global agreement to 2 years probation with assessments, treatment, full restitution on all counts. To the extent that's a sentencing issue, I cannot find the sentencing judges in this case.
Understood, Your Honor.
So, and on the case ending in 70779, she is going to be pleading no contest to counts 3 and 4. Also the charges of attempted resisting and obstructing the 1-year offense and assault and battery, the 93 offense, with dismissal of the felony, the 2 felonies.
That is a correct recitation of the plea, Your Honor.
All right. Ms. Johnson, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
My name is Teresa. Another name Johnson.
Damn jail isn't paying their internet.
Okay. Ma'am, it is this court's understanding you're going to plead no contest to 6 charges. Is that your understanding?
Yes, sir, it is.
And it's to 3 counts of assault and battery. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. Do you understand that?
Yes, sir, I do.
Late fee
And also the 3 counts of attempted resisting and
late fee plus no.
Misdemeanor
We
punishable
are
by up to
the
1 year
consent.
incarceration and a $1,000 fine.
Take
plus
our-
court costs. Do you understand that?
Yes, sir,
Back
I
up.
do.
That is neighborhood.
All right. Do you understand what a no contest plea is?
Barely.
Barely?
Yeah. Will you explain it?
Well, yeah, I could. Did you talk to your attorney about that?
We talked to chit chat, but it's never for my best
Okay.
interest, so it's like
Pardon?
nothing. I say nothing.
No, what were you saying?
I said it's not for my best interest, so we just, agree to disagree.
Okay.
I mean, you were saying that to see if I could get time to serve and go home today.
I
I've
did
been
not
here
get,
almost a year straight. I got out and went to 3 different places and came back in like less than 2 weeks. Like, been here almost like a year straight. So for the same stuff, I was like, I don't understand.
Okay, all right.
Your Honor, may I give some background to this case just for the record?
Sure.
Your Honor, these matters, all 3 matters have been adjourned several times. Public defenders, including Mr. Bellinger, but also some of his colleagues, have worked very hard in getting a good resolution for Ms. Johnson. They've looked at different treatment courts. We have been communicating essentially nonstop on this case. They have beaten me up as much as they possibly will in getting this offer. The offer is not going to approve. With that said, I don't know if the council wants to approach and we can discuss further, but I just wanted that on the record that this is not something that came about easily. It's not something we would normally just offer right away. And for somebody who has 3 pending cases of these natures, including CSC, consisting of obstructing officers and so on.
All right. Oh, I appreciate that, and I do recall that from these files. My concern is not that, or that it's going to improve in any way, but making sure that this defendant understands what she's doing.
Yeah.
I quite frankly believe it was explained. It may not. It's an interesting thing sometimes. I'm sitting up here talking, but people aren't hearing me. And so that may have been the case here. But based upon the 2 things that she has said on the record, what I'm going to do, if the people will leave the offer open, is I will adjourn this out a couple of weeks. So all of the issues that Ms. Johnson has that council can answer can be clarified.
Yes, Your Honor, we'll leave that vote.
I think that'd be the best, Your Honor. Thank you.
All right. So Ms. Johnson, here's what I'm going to do.
Okay.
Your attorneys are going to come see you again. All right.
Okay.
And the important
All
thing
right.
is that you listen to what they're telling you. Okay.
Okay.
All right.
Been
And
doing
if you
that,
have
but
questions,
okay.
and hold on, if you have questions and things, you got to make sure to ask them. And then I'm going to adjourn these out 2
Okay.
weeks. We'll come back and hopefully we can get this done. Okay.
Yes, sir.
All right.
Thank you.
Thank you.
You're welcome, Judge Simpson. I appreciate you.
Yes, ma'am.
Thank you, Jay.
Certainly.
So these are adjourned out to the 20th. Court does call the case of the people versus Jameson Boone, 2 cases.
Alice, on behalf of the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Boone, who approaches. Mr. Boone, can you take the record?
All right, what do we do?
Your Honor, we are asking to set this matter to CC to the best of my knowledge, and
For
I have.
preliminary examination.
Yeah, I'm so sorry. Yes, thank you. For preliminary examination, to the best of my knowledge, discovery is complete. I just confirmed that this morning again as well.
All right. And would people have their witnesses available on the 18th?
We'll do our best, Your Honor.
Preliminary examination in these matters will be set in person, February 18th, 2025, 9 a.m. before Judge Washington.
This stuff? I'm assembling signs for work. Piece of plastic goes on top here, and then you can slide paper in and stick it on the wall, and yeah. Oh, speak of the devil. Hello.
That'd be you.
How are you?
Good. And I can hear your echo.
Really?
Yep.
Still?
Hello.
I don't hear an echo.
You guys can hear your echo?
No,
Okay,
that's
so
not
that
good.
must be me.
Hello?
Hello.
Double hella?
I'll fix it and come back.
Okay. Godspeed.
Okay. Bye.
Bond will continue.
Thank you. Okay. Okay. All right. Thank you.
Which others? Oh, certainly. Are they, is that who's up there? No, that's Santa Lab. Oh, okay. If they switch them out, that's fine. We can do that. Court calls the case People versus Molly Fox.
Foxy.
Good morning, Your Honor. Jacob Kennedy for the people.
Morning, Your Honor. Ellen Dennis on behalf of Molly Fox.
Oh, good seeing you. All right. Your name? Thank you. All right. What are we doing?
We're going to ask for an adjournment. I just filed an appearance today and I haven't seen the police report or watched the videos.
Probable cause conference in this matter will be adjourned.
In 3 weeks?
February 27th. Will that work for you?
Thank you, Your Honor.
February 27th, 2025, 9 a.m. Bond in this matter will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Hello?
Hello?
Hello? Still there?
Yeah. Can you check your end?
I can mute and
No, something else.
Space.
Oh! I think it's actually me. Don't tell Hella. I think it's me, actually. Try again. I can't hear you at all. I think it's me in my setup. So I'm going to just go back to how you were, Hella, and then you should be good now. Sorry, guys. 1 sec. 1 second, guys. It's all Hella's fault. Just know that. Okay. Let's do this now. Now she's the perfect woman. All right, well, I'm going to go back to what I want to play. We're going to go to Jeffrey Middleton.
Oh, I start by leaning to my left. Turn on the record. All right, we're a little behind, but not too bad. Deputy Tafflinger's ready to go, so we thought we'd better get going. We have two difficult drinking driving sentences this morning. The first is Peyton Jeffrey Kraus. The file number here is 242006SD. That's you, sir?
Yes, Your
And
Honor.
you're here with your attorney, Mr. Trevor Workman.
Good morning, Your Honor.
Good morning.
Is this loud?
Daniel Frazine drew the, all right, very
I thought it was loud for me too. Oh, yeah, the booster's on. That might be why.
good. Drew the assignment of the pre-sentence on this one and has prepared the screening report. I was troubled about this case because of where Mr. Kraus lives and where he works.
Better?
Although some things have changed a little bit since the time of this incident back in November. Daniel said to me just before we walked in, they sure have done a lot. I used you as an example at new judge school last week. I didn't state your name. I just was giving an example of a collateral consequence of a criminal conviction. And one of the collateral consequences here is you're going to lose your driver's license for a period of time. And you had a very good job that was very far away from where you lived without good public transportation. And the collateral consequence of that regarding your job or residence was significant. Anyway, this is a bit of an unusual recommendation by Mr. Frazine. Mr. Workman, what would you like me to know?
Well, Your Honor, may I approach briefly?
Yes.
So one of the things that I would like to provide to the court right now is an update on the things that Peyton has been doing. I asked him to put that together and put dates and times on there. I think that Peyton is one of those, unfortunately, rare people that we see that gets in trouble, immediately recognizes how bad it was, how much he put himself and everybody else in jeopardy in his life, and began just taking steps to correct everything. By the time he came in and hired me at my office, he had already consulted with counselors and went down a path that usually a court is forcing a defendant to go down. So the court has in front of it that list there, and it's clear that he's going to multiple recovery sessions. He's going to a counselor. He's been continuing to do that for months now, and he has shared with me today that it's something that he feels he's getting something out of and isn't going to be important for him moving forward. And he said he's going to continue doing these things even when this court case is over. And based on the type of person he is shown to be and the type of things he's been doing.
Oh, half Irish. Oh, thank you so much. Oh, praying the gray away. Thank you. Gifting 5 Dolly Talk memberships. I really appreciate that, Irish. Thank you. Definitely appreciated. You are a good friend.
This is a defendant that I believe will continue to do those things. I did have an opportunity to review the report done by the probation department, as well as the private substance abuse assessment that we had done for Peyton. And I think the sort of worst thing that he has going for him here is the fact that he was able to consume enough to get that high blood alcohol content. And I think that's also why he has taken this so seriously in trying to get that under control. He has been abstinent since, and he shared with me that he's going to continue to be abstinent because he knows how much he has riding on it. He feels a lot of shame and embarrassment here, and that's another portion of this he's been working through. But I don't think this is the type of defendant that you will ever see in this courthouse again. And we're asking.
People like this are very rare. Assuming he's legitimate, not just bullshitting the judge. But it's, I don't know, I'm kind of like him, where I realize quickly that something has to change, but there's a lot of people that go through denial. So good for him.
In the court in this matter to consider fines and costs. Thank you.
I have to say, Mr. Kraus, I'm impressed by what you've done. I think so is Mr. Frazine. I'll hear from him first, then I'll speak, and then I'll hear from you. Daniel, what's your thought here?
Well, obviously, when you first look at this at quick glance, you see that very high BAC and the extreme speed involved. I think it was over 30 over the posted speed. And Ray, we could go, wow, this could have been really, really easily a serious injury or somebody even dying in it. And he understood that. And I think the thing that impressed me most was He was very humble when he called.
Seriously,
and
Helen?
spoke to me, and he was really embarrassed, but also very, very thankful that no one got hurt, because he took this to heart and he really realized what it really could have been easily. And there's a lot of people with a lot less case facts than this that aren't quite as bad, where something got a lot worse. After speaking with him, we spoke on length. He shared with me everything he's doing. For some reason, he had a very casual notion to just drink, and he'd been working hard. He took a severance package. He wanted to try something different, get a better job opportunity. And I think he just was like, well, I could use a beer or whatever. He said it was, it was just, I just kind of thought it was okay. And he goes, I can't believe I did it. And then I went out afterwards. He got caught speeding. But then right away, like within 24 hours, he started getting into services right away. And I wish I had half my people doing what he was doing. I mean, he got community work service done. He did a substance abuse assessment. And when I spoke to him, he had done over 5 sessions and he was continuing with it. So I think he said he might have 1 or 2 more under his belt by the time he came to court. He did a online VAP and he attends Celebrate Recovery. He has also secured a new job as a supervisor in our microbiology department at Abbott Labs, which is the court is aware of as a very good company we're working for. He does have a little hurdle he's going to have to deal with for the next, 30 days at least. And he's well aware of that, but can't remember the last time I recommended fines and costs and time served, but I did in this case. And I agree. I don't think he's going to be someone that's going to come back.
Mr. Kraus, what would you like me to know?
Good morning.
Good morning.
I've been regretting this ever since that night that it happened. I was super distraught immediately, and for the past few months, it's been weighing on me since. I think the victim impact panel kind of drove it home, the consequences and damages, community impact that violations like this have. And it's been really hard for me to even believe that I did something like this. Since then, I've been doing all that I can on top of getting the new job and school to try to make this right, to prevent something like this from ever happening again, which I know. So right now I'm attending the Celebrate Recovery and then counseling, really looking at perspective, impact, and then coming up with strategies for coping. And
Oh, thank you, Mo. We got a Mo raid. Hey, Nick. Much appreciated,
Hello.
guys. Hello. Can you hear me?
I can hear you, and I'm not echoing.
Yay! Told you.
Yay! It's working.
Awesome. We got a Mo raid.
Hello.
How's everybody doing? We are
Hey,
just...
Mo, you've really changed into a Swedish dude.
Well, he came along with it.
Uh,
I guess he's raiding as well. Typical Viking. So we are doing Jeffrey Middleton DUI sentencing right now for a little bit, and then we are going to raid Hella and do some of the Melody Ferris trial.
Because it was really Scott.
It was.
It was you, Scott, you.
Hey, Sneaky Pete, how are you?
Hello. Oh, hey.
Kind of boomering it
Man,
all over
there's
the
no
place.
echo. Stop it. Justin, stop it.
prevention, just to solidify my knowing that this is never going to happen again.
All right, thank you. And have a seat. I remember when you were in high school at senior honors night, all the things that go with being a high school kid, going to University of Michigan and starting a successful career. But something was going on in early November. I misunderstood. I thought you were still working at Zoetis, but apparently had you taken your severance before November 7th?
Yeah, he
or
does know
after?
him.
Yes, so I took the severance package a month before. So I was still employed by them and on their payroll, but I was looking for jobs and I landed this new one with Abbott.
All right, well, go ahead and sit down.
Mid-December.
You were bored and lonely. This is a Thursday night, November 7th. You were
Bored
drinking at home.
Ilya.
You were
How do you
drinking
feel?
enough
Shut
that
up.
you lost your judgment to drive from where you live near Marcellus or Jones or Lawton. Anyway.
Hey, let me hear
west
that
of
again.
301.
Mid-December, the one with Abbott.
All right, well, go ahead and sit down.
Mid-December.
You were bored and lonely. This is a Thursday night, November 7th. You were drinking at home. You were drinking enough that you lost your judgment to drive from where you live near Marcellus or Jones or Lawton, anyway, west of Three
Dude needs
Rivers,
a couple of
all the
cats
way
and a
to town
YouTube
to go
channel.
to the Riviera. Hopefully, they wouldn't have even served you in the condition you were in, but they were closed. So then you thought, well, I'll go to Sam's. Sam's was probably closed by that point on a Thursday night also. And then you just weren't paying attention to what you're doing. You're going 60 miles an hour down South Main Street.
Hey, it's Friday in Australia.
And then you woke up and looked in the mirror and thought, what did I just do?
He's looking in the
There were
mirror.
all kinds of red flags. One, this was a weeknight. Two, you had a
Shut
very
up.
high blood alcohol level. Three, you'd driven a long, complicated way to get from where you live to where you got stopped.
There were no cops on that route. I thought.
I would just like to say that next week will be 1 month of sobriety.
Yay!
Yes. So, ha.
But that was November.
Yes, I was very drunk in November.
Yeah.
Hey, that was 2 days after election night. I was very happy.
Yeah. It's just
Thank you.
that. Yes, and I think a celebration stream is in order.
Yes.
A stream of orange juice.
Yes.
Yeah. But yes, congratulations, Ilya.
Thank you.
Yeah.
It's been.
But meanwhile, this dude is thinking, yeah, it was the Thursday, so.
So yeah, I'm not at the point where I can judge him just yet.
No.
Maybe next week. Kidding. But thank you, everyone. Gym membership. One step at a time.
And we're gonna drive some more miles before it ended.
No.
But I guess you jumped in with both feet. Some of this you did before you contacted Mr. Workman. His office is very good at getting people plugged into these services prior to plea and certainly prior to sentencing. But you're at Pastor Jerry's Celebrate?
Yes.
How many people are attending that?
Anywhere from 20 to 50. There's a lot of people that attend, and I think it's been great. It's a good service. It makes me feel good, and then also perspective and strengthening myself to prevent something like this happening again.
Did you make new friends?
I knew somebody there before, but now most of the faces are familiar, so I greet everybody and talk to them, say hello.
Some of my sobriety court people are doing
I used
Celebrate.
to just say,
There are
hey,
a couple
asshole,
of them.
but
The original
no, I'm not
one
to
that
him.
Jerry was
And
part
ignore
of
me
was
after
at
6
Riverside
p.m.
Church.
Yeah.
And now he runs his own.
I
And
used to
I'm
just
a-
give him the Roman
I've had
salute.
some people that are still in it who turn things around. We don't know when someone gets a drunk driving charge when they're young, whether it's an indication of a big problem or a mistake that won't be repeated. You're right. It's embarrassing. It's humiliating. It's expensive. It's inconvenient.
You're streaming this right now, dude.
Thank you.
And you don't want to do it again.
Drink or get a DUI?
Yeah.
I kind of want to drink again, but
I don't want to be back
Judge
here.
McManus, the judge on the right in the pictures there, had a policy here in 3B District Court that everybody got 2 days in jail for drunk driving, 1 day sober the sentence day, and 1 day drunk the night they probably slept through. And that was the policy here for many, many years. We've faded from it recently, but there's a recent case from the Michigan Court of Appeals, City of Auburn Hills, says you can't do that. You can't have a sentencing policy in that particular jurisdiction. They sent everybody to jail or probation for driving suspended. And they said you can't do that. You can't have a sentence policy that you follow. You have to take each case on its individual merits and use some sort of unclear proportionality standard to do the sentences.
I was kind of thinking that.
We're still trying to figure out what that case means, but it does mean you can't have a policy where everybody gets 1 day sober, 1 day drunk. So the facts of your case are relatively bad in that you drove a long way. You had a high blood alcohol level.
He's going to pull an orange out of his robe any second.
You were going 60 and a 30.
Mystery orange.
But you were polite, respectful, cooperative with the officers. What did they do with your Colorado? Did they tow it or did it get parked someplace?
They towed it to Steers, and then I picked it up the next morning.
How much was that?
$210, I think.
You're such a nice fella.
Steers or Shears here in Centerville?
Shears, yes.
Yeah, I was going to say.
Oh, you're lucky. It could have been a lot
Even
worse
I
than
heard that. I don't even have Sears here.
Yeah, but
Well,
anyway, so the whole thing is
I
that
don't think we really have Sears anymore. So,
Don't you?
no. They've all closed, basically.
Right.
inconvenient nuisance. I'm sure your parents were not happy about this. All right, so what's your plan to get from where you live to Sturgis for this job at?
Gonna drive?
I don't have an exact plan yet, but I'm hoping that I can possibly lean on family to get me there for the month that I would have my license suspended.
Yeah, the problem is you're a long way from anywhere.
Yeah, it's about the same type of drive, 40 to 50 minutes to get to work.
Well, as Daniel said, it's one of our best local employers. It's a good company to work for, and but if it is proportional, I guess I'm supposed to. I'm not supposed to. I do try to take each case on its own merits. For whatever reason, the city prosecutor held the line at an OUIL in this case, even though it's a first offense. In the next case, the facts are much worse, but the county prosecutor reduced it to impaired. At that time, it was Mr. Rogness. I'm not sure they would do that now. It's a new year. The case in the city of Auburn Hills says I can't have a hard and fast sentencing policy, which I'd like to think I haven't anyway for several years. We do have our own sentencing guidelines that we use to help address this. But there's nothing to put you on probation for. You've already done everything that I was ordered to do on probation, including the victim impact panel, treatment. I don't know whether you need this, but you're doing it. And I think you're going to continue to do it. This carries a $300 fine, a $75 crime victims' rights fee, a $50 state minimum fee, a $50 screening fee. We'll cut it in half because of what you'd already done. How much was the police reimbursement, Daniel?
I think it was 120, I think.
That is correct, 120.
Yes, 120 TRPD.
That was in the police report. I guess there's nothing else in here. $595. There's no victim impact fee. You've already done it. You did post $200 a bond. So you owe $395. Let me look at that bond. Make sure it's not 2,010%.
I'm in U.S., Sasha.
No. $395 due in 30 days. We'll make that due by February 14th. One day jail credit, 1 day. You're certainly the first person this year to receive this type of a sentence. But what you've done since you got arrested, maybe more than anybody did through all of last year.
Aw.
So nice. Actually, is it going to be a
Also
good
has
sentence?
collateral consequence, trying to figure out how to get back and forth to work.
Hey, I'm back.
Anyway, you owe me $395 by middle of February. If you need more time, come see me.
Aw, you've been so sweet.
All right, Mr. Kraus, I don't expect I'll see you in here. I might run into you somewhere like a basketball game or something.
Let's hope he doesn't run into him.
At a
I
bar.
don't expect to see you in here.
You will not.
All right, you're good to
You're
go.
not.
Never say never.
No.
Thank you. All right, they just don't get any easier. Here's our next one.
Not with that attitude, Judge.
Further complicate things, Mr. Huff, who prepared the report, isn't here.
Good luck beating that DUI,
He's ill
man.
today.
Oh,
And he and I had several discussions about this case. He was very frustrated. This is file number
Sexually.
241517OD, People versus Lori Ann Demore. She's here with her lawyer, Mr. Ross Truckee. As I indicated, Matt Huff prepared the screening report, and he's recommending a jail sentence. There are several
Suffer.
issues here. One, the defendant's on probation in Kalamazoo County and was on probation at the time of this arrest. So Kalamazoo County kind of lurks in the background.
Is that the girl,
Two,
or is that the
on
woman that
one or more
ran into
occasions
the
when
birthday
Mr. Huff
party?
called Mr. Moore to discuss the case, she was
You
really
remember?
too intoxicated.
Yeah,
to
it's in
even,
Monroe County.
Oh, okay. We need to look up what happened to her.
make any meaningful communication. So that was both a violation of her probation and her bond, but she's struggling.
Mavka knows.
I had the
Oh, yeah.
Marcella, yeah.
probation department give her a preliminary
Any
breath
updates?
test this morning, just to
Yeah,
make
there was an
sure.
update.
And her numbers are 0-0, so that was
They got
encouraging.
put off.
Because the incident in question occurred early in the
3-3?
morning,
So,
and
yeah.
the facts are bad.
Already?
So
I wonder if we can get
with all
David to
that
go
in
to
mind,
it.
Mr. Truckee, what would
Yeah.
you like me to know?
Well, I guess I'd inquire of the dates Mr. Huff made these contacts, where he alleges that she was intoxicated if that's available to me.
I don't have it. Let me see if I can see. I know it was at least once. I thought it may have been twice.
I guess I bring that up because there was an adjournment in this matter from December 17th. And it was related to Ms. DeMoore's medical issue. She had a throat problem.
Yes, I remember that.
And there has been some issues medically that I just wouldn't want something that was a legitimate medical issue to be considered intoxication when sometimes over the phone, you know.
All right, fair enough. We may need to wait till Mr. Huff is available. But go ahead.
And the other thing, in a report, it indicates 17:03 hours, which if I'm doing my math, isn't that 5 o'clock in the afternoon?
Well, I'm a lawyer, so I don't know.
And the ticket is funny. In the police report, there's 1703.
7:31 a.m. is what it says on the ticket.
And to reconcile that, the bank isn't open. That's my bank.
So I wasn't here Friday. Would you email me your copy of the report?
Yeah, I can do that.
Mr. Huff refers to the report, but it's not included in my file. And I tried to get it today.
And this was a city case.
From the city, and the person that handles it for the city wasn't there. So Matt had the report, but I didn't. So I was trying to reconcile that also, that the ticket says it was at 7:31, and I thought, well, the bank isn't even open at 7:31.
I suspect the one got dropped off somewhere and it's supposed to be 17, which would put it at 5.
Which still wouldn't be AM, but.
Yeah, I don't know where the AM comes from. I've sent you the report.
All right, thank you. It may take a minute to go through our archaic, our structure. There it goes. Thank you. All right, go ahead and tell me what else you want me to know.
Well, I believe Ms.
Yeah, 17:03, which is 5 o'clock. So that makes more sense than what's on the ticket.
And I believe Ms. DeMoore has an alcohol problem, Judge. And I think she has for a long time. And I think she recognizes that.
Bold statements only on this channel.
In her interview with Mr. Huff, she talks about drinking tequila as kind of the go-to. And, you know, I've been around the block a little, but drinking straight tequila is a kind of graduated way of getting there.
What the hell is this? Dolly
thing,
reflection stream time?
I know, right? What's going on?
From her address on Lincoln.
I don't like this.
If
hold my shame inside.
Driving is acceptable in that condition, but there is something to be said for that. Of course, recognizing that it's a dense 0.3 of a mile. Mr. Moore is in here she sees Betsy at Pivotal as well as Bradley via telehealth, because I think underlying all of this, there's a couple factors that they're not excuses, but they're explanations to how she got here. Back in 2014 or thereabouts, she had a couple mental health diagnoses. There was a psychosis episode that she says was.
I think the diagnosis was just alcoholism, but I could be wrong.
They diagnosed her with a schizophrenia family disorder. She doesn't report having delusions or anything of that nature since that time, but also there was an obsessive compulsive disorder diagnosis at that time. She also suffers from severe arthritis and vascular disease and COPD, for which.
Guys, I don't have a problem. I can quit anytime I want. It's just fun to drink, okay? I can quit anytime, guys. God. All right, guys? Chill out.
Ricketa's already won.
Oh, that'll never get old.
Some combination of these lead her to receive disability income. And coupled with that, she's the primary caretaker for her 84-year-old mother who has Parkinson's. And I guess just to be candid, nothing will make you want to drink more than watching your parent die.
Should I?
No. No, leave that one alone.
You know where I'm going?
Yeah.
Okay. Say that from experience.
Hell is my better side.
Yeah,
I think that this caretaker situation is something that she wants to be able to continue doing. She worries about her mother being placed in a nursing home or what have you. But I think that it's not too hard to put these factors together and recognize how somebody gets to this point. Her conduct on the day of the incident was fairly bizarre. I think that she
she got in the bag. She was drunk, and then things that don't make sense started to make sense for her. Probably thought, hey, I'll pop up there to the bank. I got to go get my cigarettes. In the police report, it indicates she does go up there every Friday. The staff recognizes her by face. It's a small bank, and they recognized her, and they immediately noted that something was different about her that day. So I guess the key here, well, going back to the Kalamazoo case, she's reported that was related to traveling for a doctor's appointment for her mother, I believe.
Her mother also has a drinking problem.
Oh, well, there you go. These things
That doesn't
happen.
excuse having been drinking beforehand, but it kind of fits with my theory of her mental process to get to this point. Obviously, a 0.224, which is the blood alcohol I have from the lab, not the 0.24 that's indicated on the sentencing guideline. It's a distinction, not much of a difference. Once you're over 0.2, but there's 40 some years of this, and it's come to a screeching halt in 2023-24 for Miss Moore. We had a lot of discussions about sobriety court because I do see her as an intelligent person that could really benefit from that. But she doesn't want to set herself up for failure, knowing that she's not going to be a driver. That's not really a thing that she's worried about with her income and things of that nature. And she doesn't want to sign up for something only to have it be too many appointments, too many what have yous. I do believe that she would continue with her pivotal services. She reports that she's got over a month fully sober. She's not going to sit here and claim that it's been ever since my arrest, like you hear all the time, but she's over a month now with no alcohol. Reports noticing changes in her body and her well-being due to that month plus in sobriety. She's attended a few meetings. I just had a hard time with that because of transportation, and she doesn't have the technological requirements to do she has a flip phone. She's kind of old fashioned. So that's something that I've strongly encouraged her, and I think that she sees the value in. But all this being said, it's not acceptable, but it makes sense, is I guess the thing I'd want to present to the court, that we see how this all fits together to cause behavior that society doesn't want. And with that being said, a 60-year-old woman with severe health issues and a 84-year-old mother at home that requires her for cooking, cleaning, medicine, deposits. I've asked the court to consider all of those when looking at the recommendation by the agent.
Good morning.
Is it still morning?
It is here.
No, I was just trying to get chairs squared away downstairs for the meeting.
Well, you got your cane in your opposite hand, so maybe we're making some progress.
Oh, yeah, the only reason I'm really on it is so I don't slip and fall on the ice outside.
All right.
I mean, when I was moving the chairs around down the lake room, I was walking around without it.
All right, well, we're in the middle of a sentence here, so.
Oh my God, dude.
All right.
Oh,
that
let's
would be
just
alleged
come in and make
Andrew
some jokes
Roberts.
with the judge.
That's from his hip surgery.
Oh, it was a hip surgery? That's not what they told me.
Well, it was hip, wasn't brain surgery. He's doing.
Kept saying this.
All right.
He's clearly on the
Obviously,
painkillers.
this was
Yeah.
basically considered for sobriety.
It's a great day.
And one of the
We'll
ones
see
that I
him here in a
think was
month.
A matter of life and
Yeah.
death. But the other factor is the defendant's on probation, and getting arrested for drunk driving while you're on probation for drunk driving would very often result in a jail sentence. So some of the question was, would you rather do her jail time here or do it in Kalamazoo? Our suspicion was she'd rather do it here. And to some extent, Kalamazoo was waiting to see what we did.
It's a lot more fun to
they
say as well.
proceeded with their probation violation. The other factor, we were aware of her throat issues, which drinking a pint of tequila or a fifth of tequila a day certainly doesn't help in that regard.
Don't judge.
But I'm impressed if you say you've been 30 days sober. I can kind of tell just by looking at you.
That's how much I
long has it
drink.
been since you've been sober for 30 days? Years and years?
Yes, okay. I better head off and get the other stream started.
Okay.
Okay, so I'm not
So,
starting the song until you get
Sobriety
there.
court is
Okay.
one of the
Well, not
answers
you,
to
not
this,
necessarily
but
like you in there,
couple
but
problems.
like
One, you're not really
you know what
interested
I'm
in
talking
keeping
about,
your
right?
license.
So
Yeah, it'll be like
song
Two,
started.
a lot of
And
legitimate
that doesn't mean the
requirements.
stream's cancelled,
You have
right?
to get to places.
5
Now,
minutes.
you live right in town. You have to get to the day reporting center. You have to get to your counseling sessions. You have to get to some of the meetings with me. A lot of them are virtual. But you can appear in sobriety court virtually. You can appear in our treatment group virtually. But
Yes,
have
you
to
are
go to
lucky,
AA.
Nafka.
You have to go to other treatment, you have to do your testing live. And it can be expensive also. I'm doing my best, try not to make sobriety court something that only people with money can afford, because often a long time of alcohol, substance abuse disorder means you don't have any money. You've burned a lot of bridges.
I lost everything when I lost the farm. When my husband divorced me, my ex divorced me.
Yes.
I lost everything.
You lost the farm?
Nothing. He made me sign off on the farm.
Which was the Demore farm?
Yes.
Yes.
Oh, she was serious.
You're a wolf, correct?
Yes.
All right, and you married into the Demore family. I don't get into that.
I think you probably knew my brother Mike, my oldest brother Mike, that passed in April.
Yes, he just did pass.
Yeah, that's another reason then.
Well, that's water under the bridge. Whatever your reason for drinking, sure.
A reason for me to quit.
We'll redirect Sasha, but it was just posted by Half Irish.
I wish Matt were here.
She
He gives a
literally
pretty
lost the
dismal
farm.
prognosis. This case is extremely aggravated. In January of 23, she was involved in an accident where she was driving under the influence. While on bond, in that case, she was arrested for operating while intoxicated yet again. She refused the breath test and was belligerent with the officers. She hadn't yet been convicted of Kalamazoo when she got arrested for this. But
Small town, Mavka, I guess.
She refused the breath test, was belligerent with the officer. She was in violation of a restricted license at the time. She was a danger to society in 2023 and in 2024. Ms. Demore suffers from a horrendous substance abuse problem. Despite the fact she's facing serious jail time, she cannot discontinue her alcohol abuse. It is only, at this pace, it's only a matter of time before she seriously injures herself or somewhere else. Perhaps the only mitigating factor present is that Ms. Demore has acknowledged the need for help by seeing a therapist for a substance abuse issue. She was willing to admit she has mental health troubles contributing to her situation. This is a difficult case. Ms. Demore is clearly held captive by her addiction so much that she prioritizes intoxication over the safety of herself and others. Well, if it was that easy, everybody would just stop. If getting arrested for drunk driving means you never got arrested again, we sure have a lot less drunk driving.
I would note that January of 2023 was the offense in Kalamazoo, and Mr. Moore does report, it doesn't excuse, but it mitigates possibly. There were some weather-related issues with the accident as well.
That accident wasn't my fault, and my mom can vouch for that.
It doesn't excuse the blood alcohol part of it, but I don't.
The
think
accident
there was
wasn't my
necessary for
fault.
extreme
No, it was the
driving.
other vehicle that came at me, and I tried to avoid it.
All right, I don't know too much about that case. But even now, she's like, well, it wasn't my fault.
Yeah, that's not what you say, sweetie.
And
Shut up,
the drunk
Justin.
person isn't the best person to determine whether they were at fault or not. I don't know any of the facts in that case, but January of that year was.
Mainly just wanted to highlight the offense.
If this was a second offense, she would have to do 5 days in jail.
That's it?
By national highway standards, you have to give everybody at least 5 days, which I did not do recently in a case, which I'm going to need to rectify.
You're going to have to rectify it? Guy goes home and you call him up.
You did
Hey,
1
bud.
day jail. I'm going to order 5 days jail, credit 1, leaving 4 days to serve.
Surprise, motherfucker.
Hopefully that will satisfy Kalamazoo. I'm going to let the probation department schedule these days. You're on a 2-month probation while we supervise this jail time. No, I want to do a 12-month probation. We'll try this. I'm not even sure you can do this. I'm going to make the fine 0. There's a $75 crime victims' rights fee, $50 state minimum fee, $150 screening fee, $480 probation oversight fee, $120 police reimbursement, and the victim impact panel. That's $32. Fine is 0. The rest of it's bad enough. It adds up to $1,007.
Damn.
Doing 1 year. We're going to try a probation, which is not a sobriety court probation. On one hand, you don't want to go to jail, and I don't blame you there. On the other hand, you don't want to be on probation either. So I can't just pat you on the head and say, please don't do this anymore. And if it was a second offense, I would be required to order 2 days. My also hope is this will satisfy Kalamazoo, and if I put you on my probation, they may terminate you from their probation.
It's a vicious cycle. We done, Judge?
To Kalamazoo, what happened and satisfy Judge Agley, I'm not sure, but
I have a date for my probation violation up there.
we'll share this information with them. All right, you're free to go.
Thank you, Your Honor.
Thank you.
Thank you.
All right, guys, that is it. And I'm going to be ending now and sending y'all over to Hella's for Melody Ferris. Thank you, Half Irish, again for the memberships. Much appreciated. And I'll try to stream tomorrow. If I don't, I'll be back Monday with more Judge Fleischer in the morning, and then probably Judge Simpson or Middleton, or maybe another judge. We'll see. Yes, and do not drink, do not drive, all the good stuff. And really nice seeing you here, Sneaky Pete. All right, guys, I'm going to redirect y'all over to Hella. I will see you guys in a little bit. Toodles.